Today, we are in the Washtenaw County Michigan courtroom of Judge Erane Washington. We have a defendant who pleaded guilty to operating while intoxicated, but now he says he didn't really mean to plead guilty because he didn't know what that meant. His attorney makes some arguments in his favor, but also makes some admissions that might hurt him. Let's roll, law nerds.
Ypsilanti Township versus Nicholas Jones, 24T00166.
Paul Barnett on behalf of the township.
Good morning, Your Honor. Gabriel Lacey on behalf of Nicholas Jones.
Good morning. Mr. Jones, please state your name.
Yep, Nicholas P. Jones.
Thank you. All right, we're here today for a bond violation hearing. Motion to dismiss and a motion to withdraw plea, correct?
That is correct, Your Honor.
Yes, we should start with the I guess we'll start with the motion to withdraw plea first. Are you prepared to proceed on that today, Mr. Burnett?
I'm sorry, were you asking me?
Yes.
Yes.
Okay. All right. Ms. Lacey, you may begin.
Thank you, Your Honor. Yeah, at this time, I am asking that my client be allowed to withdraw his plea. I did submit a written motion that I amended and submitted to the court. I did not get a response from the people on the amended motion and brief. However, my argument is basically that my client was not afforded effective assistance of counsel, which he is, which is a right of his under the Michigan Constitution. His counsel, according to the transcripts, even admitted on the record that she understood my client's defense, but didn't understand how to defend it at a trial. My client's confidence in his attorney at that time, and probably before he had to take the plea, was shattered, and he did not feel confident that he had sufficient counsel. He did not take the plea knowing, and because he did not take the plea knowing, he did not take the plea willingly. He did not know the effects that the plea would have. He did not know at the time that it would keep him from being able to get a medical marijuana card. He did not know at the time that it was the prosecutor's burden to prove that he was operating the vehicle. He wasn't explained that by his counsel. And
I explained that to him myself on the record.
Oh, this is getting good already. Judge Washington has a long memory, and she takes meticulous notes.
he wasn't explained it by his counsel. He is supposed to get knowing a knowledge of the effects of his plea from his counsel. And so before he stood in front of you, Your Honor, to take the plea, he should have known that, one, he would not qualify for a medical marijuana card if he were to be found guilty, or the court would not recognize his medical marijuana card if he were to be found guilty of this offense. Two, that it's the prosecutor's burden to prove that he was actually the one operating the vehicle, which of course is my client's position. Since he was put on the record to take the plea in the beginning, he stated clearly he was not driving. And to further the fact that he didn't know what was going on and was just going with the motions after he spoke to his counsel in a breakout room, he pled guilty to being under the influence of alcohol. And if it wasn't for the counsel for the township speaking up and saying, Your Honor, no, it's not alcohol, it was a controlled substance, my client could be in front of you, Your Honor, right now for an alcohol charge and not the original charge of operating while intoxicated from a controlled substance. So I do not believe that his plea was made willing or knowingly. And I do believe that he had ineffective assistance counsel when he did take the plea. Jones would have insisted on continuing with the jury trial, I think, if he had more confidence in his counsel. But with his counsel admitting that she did not know how to defend his defense or represent him with that defense, How is one to be confident to go in front of a jury with their defense if their own attorney is telling them they don't know how to defend them? With a jury trial, there's reasonable probability that a jury could have found that there's no proof beyond a reasonable doubt that my client was driving that car. And he has a right to that. He has a right to counsel. He has a right to take a plea knowingly and willingly. And he has a right to be informed of all of the consequences before he takes a plea. And that was not done here.
Burnett?
Your Honor, the terms of the plea and advice of rights were all plainly put on the record by Your Honor, and Mr. Jones was asked about those and stated he understood. There's no defect on its face in the plea proceedings as they transpired. So we had to take him at his word there under oath that he understood and was advised of those rights and then waived those and entered a guilty plea. Really, the case is about, or the motion here, as I see it, is about a motion to withdraw the plea, which is governed by MCR 6.130. And under that court rule, in the absence of procedural error, and I don't think there's been any procedural error shown here, the defendant must establish a fair and just reason for withdrawal of the plea. And that's the Harris case I cite in my response. And when a defendant asserts his innocence, which apparently is what's happening here, the court should be liberal in granting that request, but it doesn't need to be requested where it's obvious, or granted where it's obviously frivolous. And in my opinion, this is a frivolous situation. He's entered a factual basis on the record himself. The police report indicates that the defendant admitted to Deputy Siller that he was driving the vehicle. There's an independent civilian witness who identified the defendant as the person who...
Your Honor, that's not true.
Please don't interrupt him. You can speak once he's done. Ms. Lacey.
Thank you.
Okay, right there is where I lost respect for this defense attorney. She is arguing zealously on behalf of her client, but interrupting like that is something I'm used to seeing uneducated pro se litigants do.
And got into that vehicle after striking another vehicle in the parking lot. So again, this is really just buyer's remorse. And that's what we have here. I understand counsel has come forward with two alleged witnesses, one of whom I believe is the mother of the defendant, who's the essence of her statement is that he came into the residence and then left. So she's not even outside to provide any probative information as to what occurred in the parking lot. The other is a person who claims to have dropped the defendant off and then left himself somehow.
Hey, you, want $50? Tell them you dropped me off in my car and then walked home.
After driving the defendant's vehicle. And I would suggest that the credibility of that statement, given the kind of overwhelming evidence to the contrary, would suggest that if you look at the totality of the circumstances, it's really not strong evidence. So I don't believe that the defendant has met his burden of showing it's in the interest of justice to allow for the withdrawal of this plea. So I would ask you to deny the motion.
Your Honor, if I may rebut briefly.
Briefly.
The witness that Mr. Barnett states identified my client admitted to the police, and if Mr. Barnett reviewed the video, he would know this, that she did not see who was driving the vehicle. She did see three individuals, and I know Mr. Barnett is trying to figure out how my witness left the scene after dropping my client off, but his own witness that he says identified my client did say that there were three individuals. And one vehicle was being followed by another vehicle, and all three of the individuals went into the home after the vehicle struck the minivan and then parked across the street. she did admit to the police on the officer's body cam that she did not see who was driving the vehicle, and she could not make a 100% identification of the driver. So I think that Mr. Barnett wanting to use that witness, I think there's holes in her story. She was outside herself drinking in the driveway of her friend's home. She does live 2 streets over, but I think that if the court would consider the situation and the condition that Mr. Jones took this plea, and the ineffective assistance of counsel he had at the time, that I don't understand, and I do not know if his counsel reviewed the video, if his counsel saw the witness wasn't as strong as Mr. Barnett would put forward here today. But
Thought you said briefly.
Mr. Jones' plea was not willingly and definitely was not knowing. And so I am asking that you allow him, in the interest of justice, to withdraw his plea and allow him his opportunity to have his case presented in front of a jury of his peers.
Thank you. Anything further from anyone?
Not from the township, Your Honor.
All right, thank you. So, a part of what happens when a motion like this is filed is basically the court gets an opportunity to go back and review the plea in great detail to find out whether there were anomalies. There were clearly anomalies. The question then becomes whether the defendant was fully informed of his rights and understood those at the time that he took the plea. And in this particular case, like the prosecutor has outlined, if there are no real concerns with the procedural posture of the case, the court has to find that there is some injustice or fairness, unfairness to the defendant based on the actual allegations of this case. And in this particular case, first of all, Mr. Jones pled on September 26th. When we look at the transcript, Mr. Jones was at one point indicating that he was not driving the vehicle. And I, at that point in time, said I was not going to accept the plea. He went into a breakout room with his attorney, who was Ms. Moeller, and they were given plenty of opportunity to discuss what his options were. He came back out. And the reason I did that is because he said, I asked, and were you operating at the time? He says, I was not. I guess I might be confused in what the process is that we're going through right now. Those are his words. I said, okay. And then I said, okay. And he said, but to answer that question, no, meaning that he was not driving. And I said, all right. So he's saying he wasn't operating the motor vehicle. Then his counselor says, Your Honor, I don't know if this would satisfy, but Mr. Jones was found seated in the vehicle when the officers arrived. So are we giving up the defense of any technical definition of operating? Defendant said, okay. And she wanted to proceed under that. And I said, it makes some sense to some degree, but it sounds like he's saying to me that at no point in time was he operating a motor vehicle at that particular address, 75 Road. And then she said, could we talk briefly in a bench conference? And then I did that. Well, and then I said, are you sure you need to be talking with me and not your client? Because I don't think my position is going to change. He has to be operating at some point. And then she says, we've had several conversations. I do understand his defense. I don't know that we are going to be able to execute the defense the way that we would need to for a jury trial. That does not sound like ineffective assistance of counsel or that she does not understand it. It sounds like she does not feel as though they can actually execute it. That is a decision on behalf of counsel. That is a trial strategy or lack of strategy or whatever. That's her decision. Then I say, we do the breakout room when we come back. They were placed in a breakout room because when I come back, I say, Ms. Moeller, you were given a breakout room to speak with your client regarding his options at that time. At this time, I believe you just stated before the case was called that you're ready to proceed with the plea. Is that correct? She says that is correct. Mr. Jones understands what that means. He will be admitted to operating and wants to accept the offer for the visually impaired charge. I said, all right. Mr. Jones, you've had a chance to speak with your attorney, sir. You understand your options, and you are choosing to move forward with this plea. No uncertainty, none. Yes, I do. And sir, you understand that means you have to admit that you were operating this vehicle at that time, if that is the truth. And you are sworn under oath. You understand that. I do understand. All right, sir. So you're still under oath. Second warning, you are still under oath. So under oath, were you operating a motor vehicle on November 4th, 2023 at the location of 7525 Warwick Road? Now, either he committed perjury or he was in fact under oath saying that he did this truthfully.
I think
Not,
sorry, Your Honor.
go ahead.
Question. Sorry.
Go ahead.
Oh, I think I did admit at the first hearing that he committed perjury, Your Honor.
Whoa. Did his lawyer just represent to the court that he committed perjury? Not sure that I would admit to a new criminal charge in order to overturn a guilty plea I'd already made. Then again, she's the one with the bar license.
His back was up against the wall. He's never been in trouble. He's never been in courts before. He was uncomfortable, very uncomfortable with his counsel. And when your back is up against the wall and you don't see any other options because you're not fully informed, as Your Honor, I'm sure knows, false confessions and pleas have been made. And this is a perfect situation for just that.
Okay. The bottom line is he said under oath that he did this. So I asked him if he understood his options. He said he did. I went over all of his rights with him. He said he understood them. He said he was waiving them. That is the choice that he made that day. It was a valid plea. If he has an issue with counsel, that's not an issue before this court. The motion to withdraw plea is denied.
Thank you, Your Honor. Can I have that in a written order, please?
Yeah, prepare it. I'll sign it.
Thank you, Your Honor.
As far as his claim that he did not understand my position with respect to the marijuana, that's not true either. On August the 21st, during that particular pretrial, I made it very clear that if it's a violation of the Medical Marijuana Act to be driving in the way that he was driving on that date, then I'm not gonna allow him to use medical marijuana when it's clear he's violating the act, that he didn't even have the authority at that time to be using in the first place. So he knew as early as August.
I'm sorry, Your Honor. Did you move on or are we still on the motion to withdraw?
Did I stutter, Ms. Lacey, about what I was saying?
Oh, Judge Washington is getting annoyed with this lawyer. She can't listen long enough for a ruling. And she claims his last counsel was ineffective.
No, you gave your ruling on the motion to withdraw, but it sounded like you were discussing more of that.
I was, and your problem?
Oh, nothing. I just wanted to, for my notes, I wanted to make sure I put it on the right form. I'm sorry. I thought you were done with the order.
All right. Next. You want to have a bond violation hearing today?
Yes, Your Honor.
All right.
You're ready to proceed. I'll call Maya Dozier.
You sure you want to do this, Miss Lacey?
It's pretty bad when the judge asks the defense lawyer if she's sure she wants the bond violation hearing, almost like she already knows how it's going to turn out.
The bond violation hearing is still needs to be had. Isn't that correct, Your Honor?
All right, as long as you understand and your client understands the repercussions, we can do this.
We don't understand the repercussions, Your Honor. Are you threatening something?
If he's in violation of his bond at the time that he was in this situation, then he can go to jail. That's not a threat, that's a consequence.
Our position is he was not in violation and the court can't prove it.
Okie dokie. All right, Mr. Barnett, you may proceed.
Thank you. We're calling Maya Dozier.
I'm here.
All right, please raise your right hand to be sworn. Do you swear or?
Thank you. Ma'am, would you state your name and spell it, please, for the record?
Maya Dozier, Mayadozzier.
And ma'am, how are you employed?
I'm employed with the Washtenaw County Sheriff Office, Community Corrections. I'm a supervision agent for Community Corrections.
Okay. And just in layman's terms, what does that mean?
I supervise clients while on bond, making sure that they abide by the conditions ordered by the court. They come in, sign in, pay a fee, and then they're tested. There's a monitored testing at our facility.
Okay. Were you the supervising agent of a person by the name of Nicholas Jones?
Yes,
Are you still his supervising agent?
I am.
Okay. And what was your understanding of what was required of Mr. Jones?
My understanding was that he was not to test for any illicit substances not prescribed to him, and that he was not able to do THC. He informed me that he did not have a medical marijuana card.
Okay. So you're testing for drugs and THC, is that?
Correct.
Okay.
And we do a PBT test for the alcohol.
Okay. How often was he, when did he start testing?
Please forgive me, I don't have the file in front of me, but I want to say sometime in June of 2024.
Okay. And how often was he supposed to test, if you recall?
One time per week. Correct. You don't know when you're going to test. You call the hotline. If you're to be assigned a number which comes up weekly, you're going to call the hotline every day as early as 5 a.m. and you're going to listen for your number. If your number is called, you have to report to Community Corrections that day before we close.
Okay. And when the person, in this case, Mr. Jones, his number was called and he reports to Community Corrections, what does he do at that point?
He reports to Community Corrections, signs in at the front desk, and then he's called by one of our drug testing agents who go into the restroom with him to monitor his drop.
Okay. And it's a urine sample that's taken, is that correct?
Correct. They do a blow test first, a PBT test to check for alcohol,
Gotcha.
if they have been drinking right now.
Okay. And was Mr. Jones compliant with coming in to test?
Yes, he was.
Okay. Were there issues with the test results?
Yes, he was positive for THC from the start of his supervision, which again, I believe to be in June of 2024 up until October 28th of 2024. All of his tests were positive. Then thereafter, up until now, they have been negative.
Good for him.
Okay. So when you get someone and a result comes back positive, what are your steps?
So what happens if they're told in the restroom after they sign a chain of custody that they will only receive a call if there's a positive result. So once the lab runs the test, if the test is positive, then they'll give Mr. Jones a call and let him know that the test was positive.
Okay. Did you have any of those conversations with Mr. Jones?
I did. I reached out to Mr. Jones and I asked him if he had acquired a medical marijuana card, and at which time he told me he had not. And at that time he was warned and counseled against further missed tests. That was, I believe, in August. The test, as I mentioned before, continued to be positive up until October 28th, I believe, was his last positive test. And again, each test thereafter has been negative.
Okay. And so the report that was issued on October 28th would reflect those positive tests in the month of October. Is that correct?
And anything prior.
So would that have been, and just focusing on the month of October, that would have been 4 tests that were positive for THC?
Correct.
Okay. And how is it made? How is the determination made that a test is positive for THC?
Well, it's ran on our machine. I can't really get too much into how the machine works. That will be for our drug testing coordinator, Michael Soshi. I know that they do run the test in-house, and it determines a positive or a negative. We don't do levels. If the client wants to contest the result, they can have it sent out to our other lab, and it would confirm or deny the positive.
And would that give a reading as to levels as well?
That part, it would, yes. They know that, and they're informed once they're testing, when they go over the chain of custody, that there's a $30 charge, but that is only if you contest it, and you have to report, I believe, within 48 hours of the positive call in order to have that sample pulled and sent to our other lab.
Okay, and so that information was conveyed to Mr. Jones at the time he was
Yes.
tested?
It
Did
should be explained every time in the restroom when you're going in. At the time that the drug testing agent is monitoring you, they go over the chain of custody each time a client is tested.
Okay.
And then they sign the chain of custody when they submit their sample.
To your knowledge, did he ever request that the sample be sent to the other lab?
No,
Okay. And you said so he had at least 4 tests positive in October, and the last being October 28th. Is that your testimony?
I'm not looking at the report right now, so I'm not sure if it went beyond the 28th because October has 31 days. But to my knowledge, I don't believe he missed any tests.
Okay.
But I do remember, I want to say that the 28th was positive in the
Okay.
last test.
And the ones prior to the 28th that were in October were also positive.
Correct.
Okay. And then you said he's continued to test after that time?
He has.
And have there been any positive tests after that time?
No, there has not.
I don't think I have any other questions for you, ma'am. Thank you.
Thank you.
Lacey.
Ms. Dozier, do you run the test on the samples that are given?
No,
But
I do not.
you did not.
No,
Ms. Dozier, do you have a medical background?
I do not.
Do you have a science background to decipher the tests?
No, I do not.
Do you know how the machine that is used to take the test breaks down because I don't have a medical background, but breaks down the person's the test subject's urine to determine whether or not it's positive for THC?
That I do not know. I'm not 100% familiar with the testing. I used to be a drug testing agent when I first started at the sheriff's department, but that was years ago. Again, those would be questions for our drug testing coordinator, Mr. Michael Soshi.
So it's your testimony today that you yourself didn't run the samples that Mr. Jones gave? And
Samples, no.
go ahead, I'm sorry.
I did not run the samples, no.
And is it your testimony today that you do not know how the results are compounded by the machine?
Correct.
Your Honor, I'm going to object to Ms. Dozier's testimony as far as the positivity or negativity of Mr. Jones's results. She doesn't even know how the machine manufactures the results. She did not administer the test for Mr. Jones. And under the best evidence rule, I think that we should have the person that took the sample, the person that understands how that machine works. And
Okay, so the defense attorney is starting to gain a little ground in this race finally. She makes a decent argument for her client regarding best evidence, but as you'll see in a minute, she's shot down.
as far as as far as Ms. Dozier having any information on how long marijuana lasts in an individual's system, I don't think she's qualified to answer that question either.
We can't really say for certain how long marijuana stays in
Ms.
a person's
Dozier,
system.
Ms.
Yes,
Dozier,
ma'am.
sorry, ma'am, you can't testify right now.
Okay.
Thank you. Mr. Burnett, response?
Your Honor, I certainly, I think can lay a more sufficient foundation for her to testify as to the at what she's testified to so far. I don't know that the best evidence rule is what really is applicable here. I think it's has a sufficient foundation been laid for her to testify as she has, and I can ask some additional questions if Your Honor wants.
I don't think I need that. I think the foundation has been laid for her to testify that she has reports that came back that it was positive, but they're challenging the positive. They're challenging whether those are accurate or not. And she can't testify as to the accuracy of them as to any lab results or lab reports. It doesn't sound like she's qualified to do that. So I think that's where the challenge lies. Am I correct, Ms. Lacy?
That's correct, Your Honor.
So I think that's what they're questioning. I mean, she can come in as the community corrections personnel and say, these are the tests we do, and these are the results we got back, but they're challenging it from a medical standpoint. And so, I mean, I can receive that, but when it comes to the medical challenge, I still have to accept that she's correct. That Ms. Dozier can't testify as to that medical part.
Understood. I wonder if we could approach, counsel and I approach briefly.
Certainly. All right, the 14B District Court is now back in session. The court will recall the case of the Township of Ypsilanti versus Nicholas Jones, 2014-00166.
Paul Barnett on behalf of the township.
Gabriel Lacy on behalf of Mr. Jones. Your Honor, thank you for that time with my client and for the conference with you and Mr. Barnett. At this time, I am going to ask the court for a bit of grace. And if the court could schedule that second date, however, if within 7 days, my client has a few more questions and I don't want to waste the court's time. If we could let the court know within 7 days whether or not we're going to proceed with that second hearing, I would like to be afforded that option. Because if we're going to take the plea, we can just get a sooner date on the schedule for him to go ahead and plead to the bond violation. But there are some questions that I still need to answer for my client. If the court would be gracious enough to allow us that.
March, does the next date, because I think you said you couldn't do March 4th. Is that
Correct.
right?
Yes.
So next date would be March 18th. Does that work? Where are we at with that? Okay. We'll go with March 18th. Please tell me that works with your calendar.
That works, Your Honor. Yes.
And we're gonna make it at 11 a.m. because like every Tuesday, it's a long docket. And that will also be, so we're not gonna change that date because that's also gonna be his sentencing date. So one way or another,
Okay.
we'll be proceeding.
Okay.
And Your Honor, just so I'm clear, that's not the date for the evidentiary hearing. We'll
No,
continue.
it's both. It is both.
Okay, so I
It's
should
the
have witnesses
hearing.
available.
And she's gonna let you know in 7 days whether.
Gotcha.
Yes.
Okay,
Yes.
understood. I'm glad
I will send an email to the court and to you, Mr. Burnett.
Okay, thank you so much.
So the bond violation hearing is going to continue if it needs to continue on that date. And then we will also have the sentencing on that date. In the interim time period, your client needs to contact the probation department so we can have his probation interview.
Thank you. Will do, Your Honor. Thank you, Your Honor.
Thank you. We'll see you then. Yes, sir. You have another question.
Yeah. There was something about a failure to appear to a
Yes.
what was it? I think like my registration or for my car registration.
License plate, yes, registration. You failed to appear on August the 15th of 2024, and a bench warrant was issued. He needs to be arraigned on that bench warrant.
Is he still able to go on the court website to set up that arraignment, or do we need to work? Okay.
24S 442 5020.
20. Okay, thank you. We'll get that taken
No,
care
no,
of.
that was the offense date. I'm not sure when the bench warrant was issued. But that was the, I'm sorry, what did you say? Okay, 1 second. It was just issued on January 30th. Oh, it says that right there. If I kept reading the note. January 30th, he failed to appear for the pretrial.
Oh, okay.
I'm trying to find the I have all my mails from court, and I don't have anything like regarding that.
We'll sort it out, Mr. Jones. We'll get you arraigned and we'll get it sorted out.
Okay. All right. Thank you.
Thank you, Your Honor.
You're welcome.
Thank you for watching. If you enjoy watching this content, please like and subscribe. It helps new channels like this one gain exposure. There is a lot more good court to come, so if you like what you saw, tell your friends. If you didn't, tell me and let me know what you'd like to see and how I can improve. Thanks.